$412,750. That's the number. Write it down if you need to, because by the end of this video, you're going to understand exactly how every single dollar of it disappeared and exactly how I got it back. My name is Claire Whitfield. I'm 34 years old. I live in Columbus, Ohio, and for 3 years, my own family stole from me in broad daylight while smiling at me across Thanksgiving dinner. Not borrowed, not mismanaged, stole, with forged signatures, with fake power of attorney documents, with a home equity loan I never signed for on a house I didn't even know had been remortgaged, with a trust fund that was supposed to be split 50-50 between me and my sister, and somehow, over 36 months, became 100% hers. I want to take you to the exact moment this story really begins. Not the moment I lost the money, but the moment I found out. I was sitting on my kitchen floor, back against the cabinet, phone still warm in my hand from a 30-minute call with a bank representative who had just confirmed in a careful, clinical voice that a home equity line of credit existed against a house I didn't legally own, secured by a signature that wasn't mine. The linoleum was cold. I remember that specifically, the cold of the floor through my jeans, because it was the last completely ordinary detail I noticed before my entire understanding of my family rearranged itself around one fact. Someone I loved had used my identity like a tool. My mother used to say it to my face like it was just a fact of the universe, like she was telling me the sky was blue. You will never be loved the way your sister is loved. She said it when I was 12. She said it when I was 26, standing in her kitchen after my father's funeral. She said it 3 weeks before I found the first forged document. She was right, actually. I was never loved the way my sister was loved. What she didn't tell me, what she couldn't have known, is that the love she was so proud of, the golden child devotion she poured into my sister Vanessa for 30 years, was the exact same mechanism that let Vanessa walk into a bank, forge my name on a deed of trust, and drain $400,000 out of my life without me finding out for almost 3 years. They thought they got away with it. They had a system. They had cover stories. They thought, me, the sister who was too trusting, too busy, too used to being the afterthought to ever look closely enough to notice. They were wrong. This is the story of how I built a paper trail that put my own sister and her husband in front of a federal judge, how a forensic accountant and I found the smoking gun that broke this case wide open, and how I didn't just get my money back, I got something my mother never once offered me in 34 years. The truth, told out loud, in a courtroom, on the record, forever. Before we get into it, this is a real story about greed, betrayal, and what it actually takes to claw every single dollar back from people who think family loyalty makes them untouchable. I'm going to walk you through this exactly the way it happened: the setup, the theft, the investigation, and the justice. Along the way, I'm going to show you the actual red flags, the actual legal terms, the actual steps I took, because if this is happening to you right now in your own family, I want you to recognize it before it costs you what it costs me. I want to be clear about something before we start, because I think it matters. This isn't a story about how families are inherently dangerous or about never trusting the people you love. It's a story about what happens when trust is never checked against evidence, not once, not ever for 34 years, and what it takes to rebuild a system of checks after that trust has already been badly broken. If you take nothing else from the next hour, I want you to take this. Loving someone and verifying what they tell you about your own money are not opposites. They were never supposed to be opposites. My family taught me they were, and that lesson cost me over $400,000. If stories like this matter to you, stories about ordinary people who refuse to be the easy mark, subscribe now, because this channel exists for exactly one reason: to make sure the people who think they can steal from their own blood and walk away clean never get to feel safe again. Let's go back to the beginning. I need to tell you about my family before I tell you about the money, because in this story, the two are the same thing. I grew up the second daughter in a house where the hierarchy was never spoken out loud, but everybody understood it anyway. My sister, Vanessa, is 3 years older than me. She was homecoming queen. She was the one my mother, Diane, took to look at wedding dresses 2 full years before Vanessa was even engaged, just to get ideas. I was the one who got asked at every family gathering why I wasn't more like her. My father, Robert, was the counterweight. He wasn't perfect, but he was fair, and fair in my house felt like being chosen. He was the one who showed up to my art shows in college when nobody else did. He was the one who told me, quietly, in the garage, the week before he died, that he'd made sure things were set up right for me and Vanessa both, equal, split down the middle. He'd worked 31 years as a machinist and a supervisor at a manufacturing plant outside Columbus, and between his 401k, a life insurance policy, and the paid-off house on Larchmont Drive, he was leaving an estate worth a little over $400,000. He died of a heart attack in March, 3 years before this story reaches its end. I was 31. Here's the first thing you need to understand about how family financial fraud works, because it's almost never a stranger with a script and a burner phone. It's someone who already has your trust, your name, your signature on file, your childhood. The scam doesn't start with a lie. It starts with a role. And the role my sister and her husband stepped into within about 6 weeks of my father's funeral was the responsible one. My sister's husband, Derek Marsh, is a financial advisor, not some fly-by-night guy. He worked, at the time, for a mid-sized wealth management firm here in Ohio, had his Series 65 license, called himself a fiduciary at every family dinner like it was a personality trait. Derek was smooth. Derek used words like estate liquidity and step-up basis at Christmas dinner, and my mother, who never finished college and always felt a little embarrassed about money, looked at him like he was speaking a language of competence she desperately wanted someone in the family to have. So when my father's will named Vanessa and me as co-executors of the estate, Derek was the one who suggested, gently, reasonably, at the kitchen table, with a legal pad and a calm voice, that it would be so much easier for everyone if Vanessa just handled the probate paperwork herself. I was grieving. I was working full-time at a marketing agency. I had, Derek pointed out, always been the creative one, not really a numbers person. Vanessa, on the other hand, had Derek right there to help her keep it all straight. I said yes. I want you to sit with that for a second, because I know some of you watching are already yelling at your screen. I said yes because I trusted my sister, because I was 31 and burying my father, and I did not have the emotional bandwidth to fight over spreadsheets, and because, and this is the part that took me the longest to admit to myself, some small 12-year-old part of me was still trying to prove I was low maintenance, easy, not a burden, not difficult, the word my mother used for me my whole childhood every time I asked the question she didn't want to answer. Here were the red flags. I'm going to list them exactly as they happened, because I promise you, if you're in a family situation right now where one sibling has taken over the finances of an aging parent or an estate, you are going to recognize at least 3 of these. Red flag number 1. Within a month of my father's death, Vanessa and Derek moved my mother's financial accounts from her longtime local bank to a new bank, one where Derek, conveniently, had a personal relationship with the branch manager. The reason given was better rates. The real reason, I'd learned 2 years later, was that the new bank asked far fewer questions on unusual activity on a $79,000 transfer. Red flag number 2, Vanessa asked me to sign what she called routine executor paperwork 3 separate times over about 4 months. I signed it in her kitchen, standing up, coat still on, because I was on my way somewhere and she made it feel urgent and small. I do not read those documents closely. One of them, I would later discover, was a durable power of attorney. Amendment that gave Vanessa expanded authority over what had originally been a joint account. Red flag number 3, and this one still makes me feel sick. My mother started saying more and more often that she didn't want to bother me with financial details because I had enough going on. That phrase, "I don't want to bother you," became the wall. It sounded like consideration. It was actually isolation. Every fraud that happens inside a family runs on the same fuel, keeping the target just informed enough to not ask questions and just isolated enough to not compare notes with anyone who would. Red flag number 4. Derek started referring to my father's estate in casual conversation as Vanessa's inheritance instead of the estate or what mom and dad left us. Language matters. People tell you what they're planning to do before they do it, if you're listening. Red flag number 5. My mother began scheduling family gatherings, dinners, holidays, birthdays, at times that consistently made it harder for me to attend on short notice, always framed as accidents of scheduling, always somehow working out so that whatever paperwork needed signing happened on days I was already rushed or distracted. I didn't clock the pattern in real time. It only became visible months later, laid out on a calendar next to the dates on the documents Martin's team eventually subpoenaed, showing that 4 of the 5 times I signed something related to the estate, I signed it within an hour of arriving somewhere, coat still on, already late for something else. And red flag number 6, the one I'd give anything to go back and catch in real time, 8 months after my father died, at a family dinner, my mother told me, completely unprompted, apropos of nothing, that she'd updated her own will and that it made more sense for Vanessa to be the sole executor and sole power of attorney going forward, since she and Derek understand all this stuff. I remember my mother looking at me and saying, almost gently, like she was doing me a favor, "You don't need to worry about any of this. You were never going to be as good with money as your sister anyway. You know that. You will never be loved the way your sister is loved." That was the subtext of every financial decision that followed for the next 2.5 years. Not Claire can't be trusted with money. Claire doesn't deserve to be trusted with money the way Vanessa does. There's a difference, and it's the difference between an accident and a design. The moment money actually changed hands, the moment that, in hindsight, was the real beginning of the theft, happened 14 months after my father's funeral. I got a call from Vanessa. She was crying, said she and Derek were in a really tight spot because of some bad investments and a medical bill from a miscarriage I hadn't even known about. She asked if I would be willing to sign off on releasing my share of Dad's life insurance payout early, before the estate was formally settled, just to get us through, with the promise that it would all be squared up the second probate closes. I said yes. Of course I said yes. She was my sister, she was in pain, and 34 years of family conditioning had taught me that saying no to Vanessa made me the cold one, the difficult one, the one who never really loved this family the way she should. I want to be specific about my own financial situation at that point because vulnerability is never just about a target's naivety. It's about timing, and they had timed this well, whether consciously or not. I was 14 months out from my father's death, still grieving, still adjusting to being an only child in practice, if not in name, since Vanessa and I had grown more distant with every handled piece of paperwork. I was renting a 1-bedroom apartment, carrying student loan debt from a master's degree I'd finished a few years earlier, and I had exactly one thing that felt like security on the horizon: the inheritance my father had promised would be split evenly. I didn't have a financial advisor of my own. I didn't have a lawyer on retainer. I had never needed one because nothing in my life up to that point had required one. That is itself a kind of vulnerability, not stupidity, not carelessness, just an absence of infrastructure that fraud is specifically designed to exploit. I signed a document Derek had drawn up. I didn't have a lawyer look at it. I didn't ask for a copy. I didn't even fully read past the first page because Vanessa was crying on my couch, and I wanted more than anything in the world for that to be the moment she finally treated me like an equal. That document, I'd learn much later, wasn't a temporary early release of funds pending probate settlement. It was a full disclaimer of my interest in a specific asset, an $81,000 joint investment account my father had set up, one I hadn't even known existed. With one signature, in my sister's living room, I had signed away $81,000, and I had no idea. That was the first theft. It would not be the last, and it would not, by a long shot, be the biggest. I want to back up for a second and talk about the mechanics of trust, because I think this is the piece people skip over when they tell stories like mine, and it's the piece that actually matters most if you want to protect yourself. Trust inside a family isn't built once. It's built in 1,000 small transactions, most of them completely unrelated to money, and every one of those transactions becomes collateral later. When Vanessa was 16 and wrecked my mother's car, I was the one who covered for her, telling my parents I'd been in the car too and that it wasn't her fault, because I didn't want to see her get grounded before her junior prom. When I was 22 and going through a bad breakup, Vanessa was the one who flew home for a weekend, and my mother talked about that trip for years. See how much your sister loves you, dropping everything like that? Even though I'd quietly paid for half of that plane ticket myself, a fact that was never mentioned again. By the time my father died, Vanessa and I had almost 15 years of these small exchanges between us, and every single one of them had been narrated by our mother as evidence of Vanessa's generosity and my debt to her. That narration is what made it so easy for me to sign documents in our kitchen without reading them. I wasn't just trusting my sister. I was making a payment on a debt I'd been told my entire life that I owed her. There's a specific conversation from this period I still replay because it's the clearest example I have of how deliberately this was constructed. About 10 months after my father died, I ran into an old family friend, Carol, at the grocery store, a woman who'd known my parents for 30 years and who mentioned, casually, that she'd heard my mother had finally gotten everything squared away with the house. I didn't know what she meant. I asked. Carol looked uncomfortable and said something vague about the refinancing Vanessa mentioned at book club, then changed the subject fast enough that I knew she regretted bringing it up at all. I didn't think much of it at the time. I filed it away as one more piece of information I didn't have the full picture of, one more area where I'd been told, gently, that I didn't need to worry about the details. Looking back, that grocery store conversation happened almost exactly 4 months before the HELOC funds started moving. Carol, without knowing it, had told me the theft was already underway. I just didn't have the framework yet to hear it. I also want to talk about my father for a moment, because his absence is the reason any of this was possible. My dad wasn't a wealthy man in the flashy sense. He drove the same truck for 20 years, packed his own lunch every day of his working life, and used to say that the whole point of saving money quietly was so nobody in the family ever had to fight over it. He believed, genuinely, that a 50-50 split written plainly into a will was airtight. He didn't anticipate that airtight documents can still be circumvented by forged signatures and beneficiary forms filed after death, because he wasn't a lawyer, and because he trusted, the way most people do, that the systems around estates and banks have more built-in scrutiny than they actually do. I think about him a lot in this story, not just as the source of the money, but as the reason I eventually fought as hard as I did. Because somewhere in those months of finding documents on my dining room table, it stopped being only about what I had lost. It became about what had been taken from him, his intention, his fairness, the one thing he'd tried to guarantee from me even after he was gone. There's one more scene from this setup period I need to give you, because at the time it felt like nothing, and in hindsight, it was everything. It was a Sunday dinner, about a year after Dad died, and Derek brought up, casually, over a pot roast, that he'd been helping Mom simplify her finances by consolidating a few smaller accounts into one. He said it the way you'd mention doing someone's yard work. Small talk, generous, not worth dwelling on. I asked, just out of politeness, which accounts? He waved a hand and said, oh, just some old CDs, nothing exciting, saving her some fees. My mother nodded along, and Vanessa changed the subject to a movie she'd seen. I didn't push. I've replayed that dinner more times than I can count, wondering what would have happened if I'd asked one more question. Which CDs? What bank? Can I see the consolidated statement? I didn't, because the entire architecture of my family had spent 3 decades training me that asking a second question after Derek or Vanessa gave an answer read as suspicion. And suspicion, in my house, was treated as a character flaw in the person doing the suspecting, never in the person being asked. That's the piece I most want viewers to take from Act 1 before we get into the discovery. Financial fraud inside a family isn't just enabled by trust, it's enabled by an existing social contract that punishes the victim for noticing, long before there's anything to notice. My mother didn't need to actively help hide the fraud for the fraud to succeed. She just needed to keep doing what she'd always done, treating my questions as evidence of my inadequacy and treating Vanessa's confidence as evidence of her competence. Derek and Vanessa didn't build a new system to steal from me. They just operated inside the one my family had already built, brick by brick, since I was a child. I think it's worth taking a moment to describe Derek himself, because understanding who he was before all of this helps explain how thoroughly he was able to position himself inside my family in the first place. Derek married Vanessa 9 years before my father died. He came from a family with, by his own account, old money that thinned out by the time it got to me, a background that gave him a natural fluency in the language of finance without, it would turn out, the ethics that were supposed to come attached to that fluency. He'd worked at 2 other advisory firms before the one he was at when this story unfolds, and I'd later learned through the FINRA disciplinary records that became public once his case was underway that he'd left the first firm following an internal dispute over documentation irregularities that was quietly settled without ever becoming a formal complaint. Nobody in my family knew that when Vanessa married him. Nobody thought to check. That's worth pausing on. Derek had, by the time he entered my family, already demonstrated a pattern once before. The tools that eventually flagged him in my case, FINRA's broker check system, which is free and public and lets anyone search a financial advisor's registration, employment history, and any disclosed disputes or disciplinary actions, existed the entire time. My family never used it because nobody imagined they needed to. He was family. Family doesn't get background checked. That single assumption, more than any forged document, is what let this go on as long as it did. Derek was, in every social setting, generous with his time in exactly the ways that build credibility. He helped my mother set up online bill pay. He reviewed my brother-in-law's coworker's mortgage refinance as a favor. He gave, unprompted, small pieces of financial advice at every gathering. Genuinely useful advice, most of it, which is precisely what made him so effective. A con built entirely on lies collapses the first time someone checks a single fact. A con built on 80% genuine expertise and 20% quiet theft can run for years because every time you verify one thing he told you, you find he was right. And that rightness becomes evidence in your mind that he must be right about everything. For almost 2 years, I didn't know anything was wrong. I want to be honest about that because I think it's important for anyone watching this who's beating themselves up right now over money a family member took from them. Fraud inside a family doesn't look like fraud. It looks like love with paperwork attached. It looks like your sister crying on your couch. It looks like your mother saying, "Don't worry about it," in a voice that sounds like care. The discovery started small and stupid, the way these things almost always do. I was refinancing my car in the spring, and my auto lender pulled my credit report as part of the process. I glanced at it, mostly on autopilot, checking my score, and I saw a hard inquiry I didn't recognize, a home equity line of credit application filed 11 months earlier with a regional bank I had never done business with in my life. My first thought wasn't fraud. My first thought was that it was a mistake, a clerical error, a case of mixed-up identity, the kind of thing you call the credit bureau about and clear up in 20 minutes. I called the bank listed on the inquiry. I gave them my name, my social security number, my date of birth to verify my identity. The woman on the phone went quiet for a second. Then she said, "I'm showing an active home equity line of credit under this social security number, opened 14 months ago, secured against a property on Larchmont Drive." Larchmont Drive was my parents' house, the house my father paid off in full 9 years before he died, the house that, under his will, was supposed to pass to my mother for her lifetime and then be split equally between me and Vanessa. I told the woman there had to be a mistake. I wasn't on the deed for that property. I had no legal ownership interest in it. I couldn't have taken out a HELOC against it even if I'd wanted to. She asked me to hold. When she came back, her voice had changed, more careful, more procedural, the tone people use when they realize they're not talking about an error anymore. "Ma'am," she said, "I'm showing your name on the deed as of 18 months ago. A quitclaim deed was filed transferring partial ownership interest to you and your sister, Vanessa Marsh, jointly, and then the HELOC was opened against that joint interest 6 months later. Both signatures are on file." I had never signed a quitclaim deed. I had never been to that bank. I had never seen a HELOC application in my life. And that's when I found the smoking gun, or at least the first one. Because if my name was forged onto a deed transferring ownership of my parents' house to me and Vanessa jointly, then forged again onto a HELOC application against that same property, someone had used my identity, my social security number, and a forged signature to pull $138,000 in equity out of a house I didn't legally own and had never agreed to encumber. I hung up the phone and sat on my kitchen floor for probably 20 minutes. Then I did the only thing that made sense. I started pulling every financial document I could find with my name on it. Over the next 6 weeks, working nights and weekends around my actual job, I requested my full credit reports from all 3 bureaus, Experian, Equifax, and TransUnion. I requested a certified copy of my father's probate file from the county probate court, which is public record. I requested copies of every document I'd signed for Vanessa over the previous 2 years, which she couldn't seem to locate when I asked. I ordered a copy of the deed history for the Larchmont Drive property directly from the county recorder's office. What I found laid out on my dining room table one Sunday night was this: the $81,000 investment account I'd signed away, thinking it was a temporary early release, gone. Fully liquidated 11 days after I signed, transferred into an account in Vanessa and Derek's names only. The quitclaim deed adding me to the Larchmont Drive title, filed with a notary stamp from a notary public I had never met, in a county I had never had a document notarized in, dated a day I could prove through my own work calendar and email records that I was 200 miles away at a marketing conference in Cleveland. The HELOC, $138,000, dispersed in 3 tranches over 4 months, the funds wired to an account ending in the same 4 digits as Derek's business checking account at his wealth management firm. And buried in the probate file, a filing I hadn't seen because I'd never been sent a copy, an amended distribution of my father's 401k rollover IRA, worth approximately $193,000, showing a beneficiary change form dated 4 months after my father's death, after he was already dead, removing me as a 50% beneficiary and naming Vanessa as sole beneficiary. The form bore my father's signature. My father had been dead for 4 months when that signature was supposedly written. I want you to really sit with the scale of that for a second, because this is where the story stops being about hurt feelings and family favoritism and becomes what it legally is: a coordinated, multi-year fraud scheme. $81,000 from the investment account, $138,000 from the fraudulent HELOC, $193,000 from a 401k beneficiary change filed after my father's death, using what appeared to be a forged signature from a dead man. That's $412,000, give or take. And I hadn't even started looking at the smaller stuff yet, the credit cards, which I'll get to. Financially, this wasn't just theft. It was the collapse of my entire safety net. I was 33 years old, and I had believed for 2 years that I had an inheritance coming that would let me put a down payment on a house, that would be my cushion if I lost my job, that represented the last tangible thing my father had ever given me. It was gone, and I hadn't even known to grieve it, because I hadn't known it was missing. Emotionally, it was worse because the person who did this to me wasn't a stranger who called pretending to be from the IRS. It was my sister. It was the person who was supposed to sit next to me at our mother's funeral one day. The person whose kids call me Aunt Claire. The person I had defended my whole life every single time someone said she was spoiled, favored, careless with other people's feelings. And relationally, this is the part nobody warns you about, the discovery didn't just cost me money. It meant I had to relearn every memory of the last 2 years through a completely different lens. The crying on my couch, the we're in a tight spot, the don't worry about it, you were never going to be as good with money as your sister anyway. Every one of those moments I'd filed under sisterly closeness or family being family had actually been a step in a plan. My first attempt to resolve this was, embarrassingly, still soft. I called Vanessa, I told her what I'd found, calmly, and asked her to explain it. I gave her every opportunity to say there was a mix-up, that Derek had made an error, that this was fixable between us without lawyers. She laughed, actually laughed, a short, disbelieving sound, and said, "Claire, you're being dramatic. Everything was handled properly. Ask Derek if you don't believe me." When I pushed, asked specifically about the beneficiary form dated after Dad died, she went quiet, then said the form had probably just been processed late and that I should stop trying to make this into something it isn't. I called my mother next. This is the conversation I still think about the most. I laid it all out, the forged deed, the fake notary stamp, the beneficiary change filed after Dad's death. My mother listened, and then she said, in a voice that still somehow sounded like she believed she was being reasonable, "Vanessa has always taken better care of this family than you have. Maybe it's time you let her have this. It would kill me to lose her over money. You'll survive. You always do. You will never be loved the way your sister is loved." There it was again, except this time it wasn't a criticism about a birthday gift or a college essay. It was a mother telling her daughter directly that losing $400,000 to fraud was an acceptable price to pay for not disturbing the golden child's comfort. I made one more attempt before I stopped trying to solve this as a family problem. I sent Vanessa a written message, email, so there'd be a record, though at the time I didn't even fully understand yet how much that instinct would matter, laying out the specific documents, the specific dollar amounts, and asking for a meeting with both her and Derek to sort this out amicably before I had to involve anyone else. Derek responded instead of Vanessa. His email was calm, professional, faintly condescending, the tone of a man used to being the smartest person in a room full of grieving women. He said the family's finances had been handled in full compliance with the estate plan your father intended, that I was understandably emotional after losing my father, and that if I insisted on pursuing baseless accusations, he would have no choice but to protect his family's reputation by whatever means necessary. That was, I'd later realize, a threat, and it was also the moment Derek made his first real mistake. He put it in writing. Because here's how they'd covered their tracks up to that point, and it's worth understanding because it's the same playbook used in family financial fraud all over this country. They exploited a genuine notarizable process, probate, power of attorney, beneficiary designations, because those processes rely on trust and speed, not scrutiny. They used a forged notary stamp from a notary whose license, I'd later discover, had actually lapsed 8 months before the date on my quitclaim deed, meaning the notarization was fraudulent twice over. They moved money quickly, in tranches small enough not to automatically trigger the kind of large transaction reporting that banks are required to flag under the Bank Secrecy Act. And they relied, correctly for almost 2 years, on the fact that grief, guilt, and a lifetime of being told I was the less loved daughter would keep me from looking too closely. What they didn't account for was that I am, by profession, someone who spends my entire working life organizing information other people find overwhelming. I do marketing analytics for a living. I build spreadsheets, I track discrepancies, I notice when a number that should be consistent isn't. They had, without meaning to, picked the wrong sister to underestimate. I also want to describe what happened after I called my mother, because the ripple effects of that conversation went further than I expected. Within about a week, I found out through my aunt, my mother's sister, who called me out of concern rather than gossip, that my mother had started telling extended family a different version of events. In her version, I was going through something, possibly related to stress at work, and had become convinced that Vanessa had done something wrong with the estate, when really, my mother explained, grief affects people in strange ways. That was the moment I understood I wasn't just fighting a financial crime. I was fighting a narrative, one that had a 34-year head start. My mother wasn't lying about me maliciously, or at least I don't think she believed she was. She was doing what she had always done, protecting Vanessa's image by reframing anything inconvenient as a flaw in me instead. I've since learned from reading about family systems and financial abuse an extremely common pattern. Family members who benefit from a golden child status will often reflexively defend that status, even in the face of hard evidence, because acknowledging the fraud means acknowledging the entire architecture of favoritism that enabled it. And that's a much bigger admission than most people are willing to make. This is also, practically speaking, why the written record became so important so quickly. Once I understood my mother was going to tell her own version of events to anyone who would listen, I stopped having any conversation about this that wasn't in writing. And I started, quietly, letting a few trusted people outside the family, my closest friend, my direct supervisor at work, for the purposes of explaining why I might need flexible hours for depositions later, know the actual documented version of what was happening so that there would be an independent record of the timeline that didn't run through my mother's retelling at all. I want to walk through the smaller theft too, because it's the piece that honestly made me the angriest in the moment. Angrier even than the six-figure numbers, because it was so petty and so personal. Buried in that TransUnion report alongside the HELOC inquiry were 3 credit cards I had never opened. A department store card, opened 19 months earlier with a $4,200 balance. A general-purpose rewards card, opened around the same time, carrying just under $7,000 in charges. And a third card, a store-branded card for home furnishings retailer with a balance of $2,600. When I pulled the actual statements, which took another round of written requests since none of these companies would simply hand over statements without proof of the fraud claim being formally opened, I found the charges themselves told their own story. Furniture, a vacation package charged to the rewards card 8 months before Vanessa and Derek posted photos from that same destination. A $500 charge at a spa on what I later confirmed, checking old texts, was Vanessa's birthday. They hadn't just taken my inheritance, they had put my name on debt, run up nearly $14,000 of it, and let my credit absorb the damage while they enjoyed the spending. Under the Fair Credit Reporting Act, once I filed the fraud affidavits and police report with each creditor, I was able to get those accounts closed and the debt removed from my credit history. But it took another 4 months of phone calls, certified letters, and follow-up before every single one of those fraudulent trade lines was gone. I want to walk through exactly how that dispute process worked, because it's genuinely useful if you ever find yourself in this position with any creditor. For each fraudulent account, I submitted a formal identity theft affidavit. The FTC provides a standardized version through identitytheft.gov, along with a copy of my police report and a notarized statement affirming I had never opened or authorized the account. Each creditor is required under federal law to investigate within a defined window once a properly documented fraud claim is filed. And during that investigation, they're required to place the disputed information on hold rather than continuing to report it as delinquent. 2 of the 3 creditors closed my dispute in under 6 weeks. The third, the home furnishings retailer, initially denied the claim, citing a partial payment that had been made on the account. A payment, it turned out, made by Vanessa herself from an account in her name, which actually ended up strengthening my case once I pointed it out, since it was direct evidence that someone other than me was managing that account. I also want to mention what this period did to my day-to-day life. Because the emotional toll of discovery isn't a single moment. It's a slow-motion unraveling that follows you into every part of your day. I stopped sleeping through the night, I started keeping a physical folder, then a second one, and then a filing box of every document, every email, every printed screenshot, labeled and dated. Because Rebecca had told me early on that organization would eventually be the difference between a case that wins and a case that drowns in its own evidence. I went to work every day and sat in client meetings talking about ad spend and conversion funnels, while underneath the table, I was running through dates and dollar amounts in my head, trying to figure out if I'd missed anything else. The hardest part, though, wasn't the paperwork. It was the holidays. 6 weeks into piecing this together, I still had to sit at my mother's Thanksgiving table across from Vanessa and Derek because I hadn't yet built the full case, and Rebecca had specifically advised me not to tip my hand before the evidence was locked down. I remember passing the mashed potatoes to the man who had, by that point, almost certainly forged a dead man's signature on a beneficiary form, and smiling because I needed him to believe for a little while longer that I hadn't noticed anything at all. I also want to describe the exact moment I decided this could no longer stay inside the family, because I think it's an important marker for anyone trying to figure out when to make that same call. It was a Tuesday night. I had just finished cross-referencing the notary stamp on the quitclaim deed against the Ohio Secretary of State's online notary public database, a free, publicly searchable tool, incidentally, that anyone can use to verify whether a notary's commission was active on a given date. The notary listed on my deed, a woman named Sherry Loeb, had a commission that expired 8 months before the date stamped on my document. That meant the notarization wasn't just possibly fraudulent, it was definitively, provably impossible. A notary cannot legally notarize a document using a commission that no longer exists. I sat there at 11 at night with that single fact glowing on my laptop screen, and something in me went very quiet and very clear. Up until that point, some small part of me had still been holding space for an innocent explanation, a miscommunication, an overzealous but well-meaning decision Vanessa had made without fully understanding the legal weight of it. The expired notary commission ended that. You cannot accidentally use an expired notary commission on a fraudulent deed. Someone had to either know Sherry Loeb personally and ask her to notarize something after her commission lapsed, or use a forged notary stamp altogether. Martin's later investigation and Sherry Loeb's own sworn statement when she was contacted confirmed it was the latter. She had never met me, never notarized any document with my name on it, and her stamp had, in fact, been reported lost 11 months before my deed was filed. That's the night I stopped hoping this was a misunderstanding and started building a case. The day after Derek's email, I stopped being a hurt daughter and started being a plaintiff. That's not a metaphor. That's literally the mental shift that has to happen if you want to win one of these cases. You have to stop asking, why would they do this to me, and start asking, what is the evidence, where does it live, and how do I get a certified copy of it? The first call I made was to a consumer protection attorney, not a general practice lawyer, specifically someone with experience in financial elder exploitation and estate fraud, because even though I wasn't elderly, my mother was 79 and had clearly been manipulated as part of this, which meant Ohio's financial exploitation statutes might apply to parts of the case involving her accounts. I found her through the Ohio State Bar Association's lawyer referral service, and I want to say clearly, that initial consultation, which many attorneys in the space offer free or low cost for exactly this kind of case, was the single most useful hour of the entire ordeal. Her name was Rebecca Solano, and the first thing she told me was, Do not confront them again. Do not accuse them of anything else in writing or in person. From this point forward, every single thing you do is about building a record, and every emotional conversation is a chance for them to get their story straight before you have the documents locked down. So that's what I did. I became a detective in my own life, and here's exactly how, step by step, because if you're in the position I was in, I want you to be able to use this as a blueprint. Step 1. I filed a police report, not because I expected the local police department to run a forensic financial investigation. Most local departments don't have the resources for that, but because a police report creates an official record with a case number, and that case number becomes the anchor for every other institution you deal with afterward. Columbus PD assigned it a case number, and having that number let me move to Step 2. Step 2, I filed a report with the FTC through identitytheft.gov, which generates an FTC identity theft report and a personalized recovery plan. This mattered specifically because identity theft, someone using my social security number and forged signature without my consent, is a federal matter that opens the door to certain protections, including the ability to place an extended fraud alert and eventually freeze new credit activity tied to my identity. Step 3, and this is the one that actually cracked the case. I hired a forensic accountant. Rebecca connected me with one, a CPA named Martin Kessler, who specialized in exactly this kind of family financial fraud, the kind that hides inside legitimate-looking probate and estate paperwork. Martin's job was to take every document I had and every document we could subpoena and build what he called a money map, a literal visual trail of every dollar from the moment it left my father's accounts to wherever it ended up. Step 4. Rebecca filed the civil complaint. This is a step people sometimes assume comes only at the end once you already have overwhelming proof, but that's backwards. The civil suit itself is often what unlocks the subpoena power you need to actually get that proof. Our complaint named Vanessa and Derek as defendants, alleging fraud, conversion, forgery, unjust enrichment, and breach of fiduciary duty tied to Vanessa's role as executor. Filing it did two things at once. It put Derek and Vanessa on formal legal notice, which Rebecca knew would rattle them, and it opened the civil discovery process, depositions, document subpoenas, interrogatories that let us legally compel banks, the Notary licensing board, and Derek's employer to hand over records they never would have released voluntarily. Martin started by requesting, through Rebecca's office, the underlying bank records for every account involved, using subpoenas tied to the civil suit Rebecca was preparing to file. Banks won't hand over another person's account records on request. You need either the account holder's consent or legal process, which is exactly why so many people give up at this stage. We didn't give up. We used the civil discovery process to compel production. Here's what the bank record showed, and this is where it stopped being a family dispute and became unambiguously a crime. The $138,000 from the fraudulent HELOC hadn't gone into some joint family account. It had been wired in 3 separate transfers of $46,000 each into a business account belonging to Derek's own side consulting LLC, a shell entity he'd formed 11 months before the first transfer, which Martin flagged immediately as a classic structuring pattern, keeping each transfer under certain reporting thresholds while still moving the full amount within a short window. And that's when I found the smoking gun. Martin cross-referenced the dates of those 3 $46,000 transfers against Derek's employment record at his wealth management firm, which Rebecca had also subpoenaed as part of the case since Derek's confessional conduct was now potentially relevant. What we found was that each of those 3 $46,000 transfers into Derek's Shell LLC happened within 72 hours of a scheduled internal compliance audit at his firm. Derek wasn't just stealing my inheritance for lifestyle spending. He was using my father's estate, my money, my sister's forged signature, my identity to plug a hole that, based on the pattern Martin identified, looked exactly like client funds Derek had been quietly borrowing against at his job and needed to replace before each audit caught the shortfall. I need you to understand what that meant. My sister hadn't married a man who made one desperate, panicked decision. She'd married a man who had, for at least 2 years, been running an ongoing embezzlement scheme against his own advisory clients. And my father's death, and my trust, and my mother's love for Vanessa, and 34 years of me being trained not to ask questions had become his financing mechanism to keep that scheme running without getting caught. Vanessa's tears on my couch, the "we're in a tight spot" phone call, that wasn't about a miscarriage medical bill. Martin's timeline showed that call came 4 days before one of Derek's internal audits. She had been recruited, whether willingly or out of her own desperation to protect her marriage, into helping her husband cover up securities fraud, using her own sister as the funding source. There were near misses in this investigation, and I want to be honest about those too, because these cases rarely move in a straight line. The first near miss. About 6 weeks into the civil discovery process, Derek's employer conducted its own routine compliance review, completely independent of our investigation, and flagged irregularities in several clients' accounts. For about 10 agonizing days, we genuinely thought Derek might liquidate the Shell LLC, move whatever remained, and disappear the money before Rebecca could get a court order freezing the accounts. Rebecca moved fast, filing an emergency motion for a temporary restraining order and asset freeze based on the evidence Martin had already compiled, arguing a substantial risk of dissipation of assets. The judge granted it within 4 days. If she'd taken the standard 2 to 3 weeks a normal motion might take, I genuinely believe the money would have been gone. The second near miss. My mother, when she was eventually deposed as part of the civil case, initially tried to claim she had personally authorized the beneficiary changes on my father's 401k. An attempt, we believe, to protect Vanessa by taking legal responsibility onto herself, even though she had no legal authority to change beneficiary designations on an account that wasn't hers. That claim fell apart almost immediately because Martin had already established through the plan administrator's own records that the beneficiary change form had been submitted electronically through a portal that logged IP addresses, and the IP address matched Derek's home office, not my mother's house. I want to be honest about what this investigation cost me before it ever paid anything back, because I think that honesty matters for anyone weighing whether to pursue a case like this. By the 7-month mark, I had spent just over $31,000 of my own money on attorney's fees, the forensic accountant's hourly rates, the questions document examiner's fee, court filing costs, and certified copies from 3 different counties. Rebecca worked with me on a partial contingency arrangement for the civil recovery portion once the evidence was strong enough to justify it, which helped enormously. But the early months, the months where we were still building the case rather than litigating it, came entirely out of my own savings. Same savings I'd been counting on as a cushion before any of this happened. There is a particular kind of dark irony in going into debt to prove that you were robbed. I also want to mention the toll it took outside of money. I missed 2 of my closest friends' baby shower planning meetings because I was pulling date records. I turned down a promotion at work that would have required travel because I couldn't commit to being unavailable during a period when depositions or subpoena responses could land at any time. I saw a therapist for the first time in my life, specifically because Rebecca mentioned, almost in passing, that clients who had some kind of support system tended to make better witnesses under cross-examination, steadier, less reactive, less easily rattled by a defense attorney trying to provoke an emotional outburst on the record. That single practical piece of advice turned into one of the most valuable things to come out of this entire ordeal because it gave me language, finally, for what 30 years of being told I was the less loved daughter had actually done to me. By this point, roughly 7 months into the investigation, we had enough. A documented money map, forged signatures analyzed and confirmed fraudulent by a certified question documents examiner Martin brought in, a fraudulent notarization, a shell LLC receiving structured transfers timed to Derek's employer's audit schedule, and a beneficiary form submitted from Derek's own IP address after my father's death. Rebecca made the call to bring in law enforcement at the federal level, not just the civil track. Because the fraud crossed state lines, some of the wire transfers routed through an out-of-state correspondent bank, this fell under federal wire fraud jurisdiction. And because Derek's conduct involved his role as a registered financial advisor misusing client funds, it also triggered interest from the SEC and FINRA, in addition to the FBI's Financial Crimes Unit. We submitted our full evidence package, organized exactly the way Martin had built it, to the FBI field office, and separately filed a formal complaint with FINRA regarding Derek's advisory conduct. I want to be honest that handing the case to federal investigators didn't feel like relief the way I expected it to. It felt, at first, like losing control of something I had spent almost a year building with my own hands. Rebecca warned me about this specifically. She called it the handoff moment, the point where a case stops being something the victim can push forward through sheer will and becomes something that moves at the pace of an institution with its own priorities and its own timeline. I had to learn to trust a process I couldn't see the inside of. Submitting our binder, 340 pages, tabbed and indexed the way Martin had taught me, bank records next to notary verification, next to the deed history, next to the IP address logs, and then waiting. I remember the exact moment the FBI agent assigned to the case, Special Agent Patricia Nunez, called me to confirm they were opening a formal investigation. She said something I've never forgotten. In 11 years doing this job, the cases that fall apart are the ones where the victim gives up before the paper trail is finished. Yours isn't going to fall apart. You already did the hard part. I hadn't thought of myself as someone doing the hard part. I'd thought of myself as someone too hurt to let this go. It turns out those can be the same thing. I want to spend a minute on the social media evidence because it ended up mattering more than I expected going in. Vanessa is and always has been an active poster, vacations, home renovation projects, a fairly public account with a few thousand followers built around family lifestyle content. Martin's team, as part of the broader evidence gathering, archived and timestamped a series of her public posts using a legitimate web archiving tool, cross-referencing the dates against the transfer dates in the money map. It wasn't that the posts alone proved anything. A boat, a vacation, a kitchen renovation aren't illegal. But when Rebecca's office laid the timeline in front of a mediator during a required pretrial settlement conference, showing Derek's Shell LLC receiving $46,000 3 days before a documented company audit, followed 9 days later by a public post of Vanessa on a beach in Turks and Caicos, the pattern did something that raw bank statements alone hadn't fully done. It made the theft legible as a lifestyle choice rather than an accident, and that shift mattered enormously once we got into settlement negotiations because it undercut any argument that this had been a series of well-intentioned but poorly executed financial decisions. I also learned over the course of this investigation just how much of the process depends on your own willingness to keep showing up for unglamorous, tedious tasks. I spent entire weekends at the Franklin County Recorder's Office pulling deed histories. I spent hours on hold with 3 different banks, each time having to re-explain the entire situation from scratch to a new representative, each time having to actually fax in this day and age, notarized affidavits of forgery to unlock the next piece of information. I learned what a certificate of authenticity from a questioned document examiner actually looks like, and I sat at Martin's office and watched an examiner named Dr. Alan Reyes lay my father's known signatures next to the beneficiary form under raking light and UV examination, showing me the tremor patterns and pen lift inconsistencies that proved, to a professional certainty, what I already knew in my gut. My father never signed that document. He couldn't have. he was already gone. There was a moment, sitting in that office, watching a stranger with a magnifying loupe confirm what my own family had spent 2 years denying, where I finally let myself cry. Not out of grief this time, but out of something closer to vindication. It is a very particular kind of relief, being believed by an expert after being disbelieved by your mother. I want to describe Vanessa's deposition because it's the moment I finally fully understood the scope of what had happened, and it happened almost by accident. Depositions are sworn testimony taken under oath outside the courtroom, usually in a conference room with a court reporter transcribing every word, and they matter enormously in civil cases because inconsistencies between deposition testimony and later trial testimony can be used to impeach a witness's credibility. Rebecca had prepared me for weeks about what to expect sitting across the table from my own sister, while opposing counsel, Derek and Vanessa's defense attorney, tried to control the narrative. Vanessa held together for the first hour, giving clipped, careful answers about the quitclaim deed, insisting she didn't recall specific details about how it was filed. But Rebecca had a strategy. She moved through the timeline slowly, document by document, forcing Vanessa to either commit to a specific false story or admit she didn't know. And when Rebecca finally placed the beneficiary change form in front of her, the one dated 4 months after our father's death, and asked directly whether she recognized the electronic submission record showing Derek's home IP address, Vanessa's composure cracked for the first time in the entire 2-year ordeal. She didn't confess outright, but she stopped saying, "I don't recall." She started saying, quietly, "I think you'd have to ask Derek about that," over and over for the rest of the deposition, and anyone in that room could see exactly what that pattern meant. She wasn't protecting an answer she didn't have. She was protecting herself from an answer she did. That deposition is also where I learned something that reframed the entire case for me. Vanessa had, at one point, tried to stop Derek. There was a single email produced in discovery sent by Vanessa to Derek about 5 months into the scheme that read in part, "I don't think we should keep doing this. It's Claire's money too, and I feel sick about it." Derek's response, 3 lines long, said that if she wanted to explain to the compliance department where the missing client funds had gone, she was welcome to bring it up herself, but that until she had a better solution, this was how they were keeping the family, meaning his career, meaning their marriage, meaning the house, intact. I don't share that to excuse what Vanessa did. She still forged a deed. She still helped falsify a beneficiary form. She still let the theft continue for another 1.5 years after that email. But it did change something in how I understood the shape of what happened to my family. Not 2 equal architects of a plan, but one man who built a trap and a wife who, at least once, tried to climb out of it, and then out of fear or loyalty or both, climbed back in. The federal investigation took another 11 months. I'm not going to pretend that timeline is glamorous or fast, because it isn't. And I think it's important to say that out loud for anyone watching this who's in month 3 of their own case and wondering if it's ever going to end. It ends, it just doesn't end on your schedule. Here's how it broke, piece by piece. FINRA's investigation into Derek moved first, since regulatory proceedings often move faster than criminal ones. Derek was found to have misappropriated client funds from at least 4 separate advisory accounts at his firm, totaling just over $300,000, using the exact rolling cover-up pattern Martin had identified. Borrow from clients, replace it before an audit using outside money. Repeat. FINRA barred him from the securities industry for life and referred the matter to the SEC for further action. His firm terminated him the same week and, under their own fiduciary obligations, began making clients whole through their errors and omissions insurance, which incidentally gave federal investigators an entirely separate, independently verified confirmation of Derek's embezzlement, one that had nothing to do with my family's money and everything to do with corroborating that this was a pattern, not an isolated incident. The FBI's wire fraud case moved next. Derek was indicted on multiple counts of wire fraud under 18 U.S.C. Section 1343 in connection with the structured transfers used to disguise the movement of my father's estate assets into his shell LLC, and separately on charges related to the misappropriation of his advisory client's funds. Vanessa was indicted as well. This is the part of the story that still knots up in my chest every time I tell it, on charges of forgery related specifically to the fraudulent quitclaim deed and her role in the falsified beneficiary change form, and on a conspiracy charge tied to her participation in structuring the HELOC transfers. My mother was not criminally charged. The prosecutor's office determined, based largely on the deposition evidence and the IP address findings that cleared her of directly submitting the fraudulent beneficiary form, that while she had been willfully blind, choosing not to ask questions she should have asked, there wasn't sufficient evidence she had knowingly participated in the forgery or the wire transfers themselves. I have complicated feelings about that. I still do. But I've made peace with the fact that willfully blind and criminally guilty are not legally the same thing, even when they feel morally identical. The civil case, which Rebecca had been running in parallel this entire time, reached a judgment before the criminal cases even went to trial, because Derek and Vanessa, facing overwhelming documentary evidence and the very real threat of a public federal trial, agreed to a settlement rather than fight a civil judgment they had almost no chance of winning. The civil judgment: full restitution of the $412,750 identified in the money map, plus prejudgment interest calculated from the date of each theft, plus attorney's fees, for a total civil award of just over $461,000. I sat through the mediation session where that settlement was actually hammered out, in a conference room 2 floors below Rebecca's office, with a retired judge serving as mediator, moving between 2 separate rooms, mine and theirs, the way these sessions usually work, carrying offers and counter-offers back and forth over the course of an entire day. Derek and Vanessa's attorney opened with an offer covering barely a third of what Martin's money map had documented, framed as an amount that reflects ambiguity in some of the transactions. Rebecca rejected it within about 10 minutes, walked back into my room and said calmly, "They know exactly what we have. This is just them checking whether we'll take less because we're tired." We weren't tired. By the end of that day, after 6 more rounds of back and forth, they agreed to the full amount, because the alternative Rebecca kept putting in front of them was straightforward: a public trial, a jury, and a courtroom full of exhibits, including a forged dead man's signature, all of it becoming part of the public record regardless of the outcome. Here's the part that matters just as much as the number, though. A judgment on paper doesn't put money in your bank account. Collecting on a judgment is its own separate fight, and this is something almost nobody tells you going into one of these cases. Derek and Vanessa didn't have $461,000 sitting in an account waiting to be handed over. So Rebecca's office moved to actual asset recovery, filing liens against remaining real property, garnishing a portion of Derek's future wages once he found new, non-advisory employment, and critically, working with the court to place a judgment lien against Derek and Vanessa's home, which they were ultimately forced to sell, with the proceeds applied directly to the judgment. Between the forced sale of their home, the garnishment order, the remaining funds recovered from the Frozen Shell LLC accounts before Derek could dissipate them further, and a portion of restitution ordered as part of Derek's eventual criminal sentencing, I have, as of the time I'm telling you this story, recovered just over $390,000 of the $461,000 judgment, with a structured payment plan in place, enforced by the court, for the remainder, coming directly out of Derek's wages for the foreseeable future. Derek pleaded guilty to wire fraud and to the client embezzlement charges as part of a plea agreement and was sentenced to 7 years in federal prison, followed by supervised release, along with a restitution order covering both his advisory clients and separately the portion of my family's losses tied directly to his conduct. Vanessa pleaded guilty to a reduced charge of forgery and conspiracy to commit wire fraud in exchange for her cooperation testifying against Derek regarding the Shell LLC and the timing of the transfers relative to his employer's audits. She received 3 years of probation, 500 hours of community service, and a felony record that will follow her for the rest of her life. I understand, watching this, some of you might feel Vanessa's sentence sounds light compared to the scale of what happened. I had that reaction too at first. Rebecca walked me through the reasoning, and I think it's worth passing along. Federal and state prosecutors routinely offer reduced sentences in exchange for cooperation that helps convict a more culpable co-defendant, especially in complex financial cases where proving intent requires an insider's testimony. Vanessa's cooperation, her deposition testimony, and later her formal cooperation agreements provided corroborating detail about the Shell LLC's purpose and the audit timing that strengthened the case against Derek considerably. It was, in the prosecutor's calculation, a worthwhile trade, a lighter sentence for Vanessa in exchange for a stronger, faster, more certain conviction of Derek, the person whose original embezzlement had set the entire scheme in motion. I was in the courtroom for both sentencing hearings. I gave a victim impact statement at Derek's. I did not, in the end, give one at Vanessa's. I submitted a written statement instead because I honestly wasn't sure I could stand in a room and look at my sister without saying
something I'd regret. And Rebecca gently suggested that a written statement would carry the same legal weight without costing me anything I might need later. I want to share part of what I said at Derek's sentencing in my own words because I think it matters for anyone who might one day find themselves standing at a podium in a federal courtroom trying to compress years of damage into the few minutes a judge allows. I told the court that the hardest part of this case was never the paperwork or the phone calls or the years of forensic accounting. The hardest part was learning to distrust my own memory of my family, having to go back through birthdays, holidays, ordinary Tuesday dinners, and ask myself which of those moments had been genuine and which had been calculated, and realizing I would probably never fully know the answer for certain. I told the judge that Derek hadn't just taken $400,000. He had taken my ability to trust my own read of the people closest to me. And that particular theft doesn't show up on any balance sheet, doesn't get restored by any restitution order, and doesn't heal on any court-ordered schedule. I told him, too, that I wasn't asking for the maximum sentence out of anger, even though I had plenty of it. I was asking for it because every dollar he diverted from his advisory clients into that Shell LLC to cover his own theft has been possible specifically because he identified me, correctly, as the family member least likely to be believed if I raised concerns. That wasn't bad luck. That was a calculated risk assessment. And the sentence, I said, should reflect that this was not an impulsive crime, but a sustained, deliberate operation built on exploiting exactly the kind of family dynamic he knew from years of Sunday dinners that he could rely on. The judge, in handing down the sentence, specifically referenced the pattern of timing transfers to precede internal audits as an aggravating factor, showing sophistication and intent, which is part of why Derek's sentence landed on the higher ends of the federal guideline range rather than the lower end his defense attorney had argued for. My mother did not attend Derek's sentencing. She attended Vanessa's, and afterward in the courthouse hallway, she said the last thing she has ever said to me directly, "I hope you're happy now that you've destroyed this family." I didn't destroy anything, and I told her so. I said, "Mom, I didn't forge anyone's signature. I didn't file a beneficiary form after Dad was already dead. I didn't build a shell company to hide stolen money. I just refused to stay quiet about it." She didn't have an answer for that. We haven't spoken since. I've thought a lot in the months since about why my mother's hallway comment landed the way it did. Why, of everything said in 2 years of depositions and hearings and courtroom testimony, that one sentence is the one that still wakes me up sometimes. I think it's because it confirms out loud, in her own words, the exact calculation I'd spent my whole life sensing, but never hearing spoken plainly. That the family, to her, meant Vanessa, not the four of us, not fairness, not even, in the end, the truth. Protecting Vanessa's comfort was the family, as far as my mother was concerned, and anything that disrupted that comfort, even a lawful thievery. Documented, court-validated pursuit of justice counted, in her mind, as an attack on the family itself rather than an attempt to save what was left of it. I don't say that to be cruel about my mother. I think in her own way she believes it. I think loving one child more than another, when it happens young enough and consistently enough, can calcify into something a person genuinely can't see anymore, the way you stop noticing a smell you've lived with for years. That doesn't make it less damaging. It just makes it, in a strange way, less personal. Not something done to me specifically, but a pattern she'd probably have repeated with almost anyone standing in the position I was standing in. I want to give you the twist now, because I promised it and because I think it's the piece of this story that actually explains everything else. What the money was actually used for. It wasn't a lavish lifestyle, though there was some of that. A boat, a couple of expensive vacations Vanessa posted about, the kind of thing that used to make me feel, quietly, like maybe I really was the less deserving sister. But the bulk of it, the majority of that $412,000, went exactly where Martin's money map showed it going, into Derek's Shell LLC, and from there, back into the accounts of his own advisory clients to cover up money he had already stolen from them before my father even died. Derek wasn't a man who saw an opportunity and took it once. He was a man already drowning in his own theft, who married into a family with an inheritance on the horizon, who groomed himself into the role of the responsible one, specifically because he needed a source of clean-looking money to keep his real crime hidden a little longer. My sister's crying on my couch wasn't really about a miscarriage medical bill, and it wasn't really even about her own greed. It was, as close as I can tell, about a woman terrified of losing her marriage and her husband's career, doing whatever it took to buy him a little more time, using the sister she'd been trained her whole life to see as less important as the ATM. Martin's forensic work eventually traced Derek's original embezzlements back almost 2 years before my father even died, back to a period when Derek had quietly began making unauthorized trades in 2 clients' discretionary accounts, chasing losses from an earlier bad position by taking increasingly aggressive risks with money that wasn't his to risk. Then, covering the resulting shortfalls by moving funds between accounts in a way that looked, on a surface-level review, like normal portfolio rebalancing. It's a pattern forensic accountants call robbing Peter to pay Paul, and it works for a while as long as the person doing it can keep finding a new source of Peter. My father's death and the estate that came with it wasn't the beginning of Derek's crime. It was simply the newest, most convenient Peter he found once his usual sources ran dry. That's what made the internal compliance audits so dangerous to him, and it's why the timing correlation Martin found was so damning. Every time an audit approached, Derek needed a fresh injection of outside-looking money to make the client accounts appear whole again, however briefly, and every time, for a stretch of nearly 2 years, that money came from my family, first from smaller, easier-to-justify amounts, then, as his need grew and the stakes grew with it, from the HELOC, from the investment account, and finally from the 401k beneficiary change. Each theft larger than the one before it, because each audit he needed to survive demanded more than the last one had. My financial recovery is still ongoing, technically, since the restitution and garnishment payments continue on a schedule the court set. But financially, I am, for the first time in 3 years, stable. Stable in a way that's different from before, because it isn't passive anymore. I have a credit freeze permanently in place with all 3 bureaus, lifted only when I personally authorize a specific application. I review my credit reports quarterly, not annually. I have my own attorney on retainer for anything involving my mother's estate going forward, because I will never again sign a document at someone else's kitchen table without reading every page myself. And I found something else, in the middle of all of it, that I genuinely did not expect. Martin, the forensic accountant, introduced me, professionally at first, going over the final numbers on the case, to a colleague of his, a fraud investigator named James, who consults on exactly these kinds of family and elder financial exploitation cases. We started talking about the case, then about work, then about everything else. He is, in every way that matters, the opposite of what I grew up believing love was supposed to look like. Steady, transparent, someone who has never once made me feel like I needed to earn a place at his table. The first time I told James the whole story, start to finish, he didn't flinch, and he didn't try to fix it for me the way well-meaning friends sometimes had, jumping straight to, well, at least it's over now. He just asked good questions, the kind Martin and Rebecca had trained into me over 2 years of building a case. Questions like, how did you know to check that? And what tipped you off first? The kind of questions that treated my own competence as a fact worth being curious about, rather than a surprise worth commenting on. It sounds small. After 34 years of being told, one way or another, that I was the less capable sister, it did not feel small at all. We've been together for a little over a year now. He knows the entire case file better than almost anyone outside of Rebecca's office, partly because of what he does for a living, and partly because I've never had to hide any of it from him, never had to manage which version of the story was safe to tell. There's a specific kind of relief in that, one I didn't know I'd been missing until I had it. Being with someone who has seen the worst, most humiliating, most financially devastating chapter of your life laid out in bank records and forged signatures, and who looks at all of it and sees, simply, someone who fought for herself. Not someone dramatic, not someone difficult, just someone who refused to let it go. My mother was right. I was never loved the way my sister was loved. I found something better, a family, built from people who chose me, that doesn't run on comparison at all. I want to talk for a moment about what recovery actually looked like on a practical, unglamorous level, because I think the phrase getting your money back makes it sound cleaner than it is. The first check I received, a partial disbursement from the Frozen Shell LLC account, released once the court finalized the asset freeze into a formal recovery order, was for $11,000. I remember staring at it and feeling almost nothing, which surprised me. I'd expected triumph. What I actually felt was exhaustion, the particular kind that comes after you've been running on adrenaline for so long that your body doesn't know how to downshift. The bigger recovery came in stages over the following year. The proceeds from the forced sale of Derek and Vanessa's home, roughly $160,000 after the mortgage and liens were satisfied, applied directly against the judgment. A lump sum restitution payment ordered as part of Derek's federal sentencing, drawn from assets seized in connection with his advisory client embezzlement case, of which a portion was allocated to me as a named victim in his criminal case, and the ongoing wage garnishment, which nets a fixed amount from Derek's paycheck every month, deposited automatically, a slow and steady reminder that this is not actually over. It's just no longer something I have to fight for by hand. I also want to be honest about the parts of this that money couldn't touch. I have not spoken to my mother in over a year. My nephew and niece, Vanessa's kids, are 8 and 11, and I don't see them anymore, which is a loss that has nothing to do with dollar amounts and everything to do with the collateral damage fraud does to everyone standing near it, including people who did nothing wrong at all. I think about them sometimes, and I hope that someday, when they're old enough to understand what happened, they'll know that none of this was ever about them and that the door isn't permanently closed on my end. What I gained, though, is something I don't think I could have gotten any other way. I gained a working knowledge of exactly how estates, deeds, beneficiary designations, and credit systems function, knowledge I now use informally to help friends and coworkers who come to me half embarrassed, describing situations that sound uncomfortably familiar. I gained a level of financial vigilance that, while it was born out of trauma, has genuinely made me better at managing my own life. And I gained Rebecca and Martin, who started as professionals I hired and became, over 2 years of fighting this together, something closer to allies, the kind of people who show up for you not because they have to, but because they watched you refuse to quit. Before you go, I want to leave you with the actual warning signs, because if this story resonated with you, there's a real chance it's because some part of you is watching it happening in your own family right now in a smaller, earlier stage than mine had reached. Watch for a family member who suddenly wants sole control of shared financial decisions and frames it as taking the burden off you. Watch for phrases like, "You don't need to worry about the details," or "You were never really good with this stuff anyway." Those aren't compliments, and they aren't neutral. They're often the exact language used to keep someone from asking questions. Watch for documents you're asked to sign quickly, under emotional pressure, without being given time to read them fully or show them to your own attorney. A legitimate document can wait 24 hours for you to review it. If someone tells you it can't, that urgency is the red flag, not an inconvenience. Watch, too, for accounts, banks, or advisors that change suddenly after a death or a major life event in the family, especially if the change centers financial relationships around one person's spouse or outside advisor. Watch, too, for a specific pattern around notarization and witnessing. Documents signed away from a bank branch, at a kitchen table or in a car, notarized by someone you've never met, or documents where you're told the notary already stamped it, you just need to sign. A legitimate notarization requires you to appear in person, present valid identification, and sign in the notary's actual presence. If you signed something and never once stood in front of the person whose stamp appears on the document, that document may be fraudulent and you have the right to check. And here's how to protect yourself, concretely, starting today, whether or not you think anything is wrong. First, pull your credit report from all 3 bureaus at least twice a year. You're entitled to free weekly reports at annualcreditreport.com, which is the only site authorized under federal law to provide these free reports. Look specifically for hard inquiries you don't recognize and new accounts you didn't open. Second, set up a credit freeze with Equifax, Experian, and TransUnion individually if you're not actively applying for new credit. It costs nothing under federal law, takes minutes to set up online, and takes minutes to lift temporarily whenever you legitimately need new credit. A freeze would have stopped my HELOC before it ever got approved. Third, if you're a co-executor, co-trustee, or named beneficiary of any estate, request your own certified copies of every filing directly from the probate court yourself. Don't rely on a co-executor to forward documents to you. Probate records are public, and you are entitled to pull them independently, in person, or often online, depending on your county. Fourth, if you're asked to sign anything related to an estate, a deed, a power of attorney, or a beneficiary change, take it home. Read every page. If anyone tells you it can't wait or that it has to be today, that urgency is itself the warning sign. A legitimate document survives a 24-hour delay and a lawyer's review. A fraudulent one often can't. Fifth, check the notary. Every state maintains a searchable database of active notary commissions, usually through the Secretary of State's website, and it's free to use.
If a notarized document was signed on a date when the listed notary's commission had lapsed, that's not a technicality, that's proof. And sixth, the one I want to leave you with most, if something feels off even slightly, even if it feels disloyal to ask, get a consultation with an attorney before you sign anything else. Most consumer protection and estate attorneys offer an initial consultation at low or no cost, specifically because they know how often that first conversation is the only thing standing between a family and years of cleanup. You are allowed to ask questions about money involving people you love. Asking is not betrayal. Silence is what fraud depends on. I didn't get my sister back. I didn't get my mother back. Not really, not in any way that feels like the mother I thought I had. But I got the truth, on the record, permanently, in a way no one in my family can ever again talk me out of. And I got almost $400,000 back, dollar by dollar, through a paper trail I built myself, out of nothing but bank records and refusing to stop asking questions. I think about my father sometimes, standing in that garage the week before he died, telling me things were set up right, equal, fair. He was right about his intentions. He just never imagined how far someone would go to override them or how long it would take his daughter to notice. I like to believe that if he could see where this ended, the judgment, the restitution, the truth finally sitting out in the open where nobody in my family could reshape it into something more comfortable, he would recognize it as exactly the fairness he tried to build in the first place. It just took the long way around to get there. If you've ever been scammed by a stranger or by someone who was supposed to love you, I want to hear about it. Tell me what happened in the comments. Tell me what the first red flag was looking back, because I promise you, someone reading this right now needs to hear it before it's too late for them too. Subscribe if you want more stories like this one, and the next time someone tells you that you'll never be loved the way someone else is, don't argue with them. Just make sure you're never financially dependent on their definition of love ever again.